Now, here I find that your reason for the decision was profoundly insightful, as is many other of your judgments. But here you say, if the resolution of the problem is reasonably predictable, using standard practice or routine engineering, there is no technological uncertainty in this context. Well, interestingly enough, the CRA effectively has cut and pasted your decisions on Northwest Hydraulics, and they've superimposed them into their own guidance documents. I'm sure you're aware of that. In most cases, it's a fairly accurate extraction, and other times they've added some things to that because it hasn't been accredited per se, but the content is largely from Northwest Hydraulics. Now, one of the points in the eligibility of work document 86.4R3 and some of the other guidance documents did talk about the same thing. This came from you. And what's interesting is when we see a decision coming down from CRA that says the work was not qualified because standard procedures were used to resolve the problem, what part of that, of your decision, do you think they might be ignoring?
Well, they did not give sufficient, in my view, sufficient effect to reasonably predictable. I think that if there's reasonable predictability, the fact that only routine engineering is utilized in reaching that conclusion, I do not think disqualifies the scientific research.
That is the heart of what we're talking about and perhaps why there's such a disparity. So what we're really saying, or at least what Chief Justice Bowman is saying in his decision, it's not that work that's performed using routine procedures is ineligible for SR&ED at all. It's that where where the result or the problem is reasonably predictable using routine engineering. So it might be that bona fide SR&ED activity, legitimate work, is performed using known techniques, standard procedures, as it were, but the result was not reasonably predictable. The omission of the term reasonably predictable is an enormous reason, in our opinion, as to why we're seeing the misapplication of the law.
Yes, I believe that so.
So one of the things that I would almost be inclined to ask you about if I was, thinking about it driving over here to meet with you, was, in reality, is it more the actual tasks performed, or is it not the resultant knowledge that constitutes an advancement?
I think it's the latter.
Chief Justice Bowman, I've got to say, I've quoted you countless times. And the purest definition for SR&ED that I have seen is your rhetorical question where you asked, was there an advancement? That is to say, an advancement in the general understanding. We're really talking about knowledge gained. And one can look at tasks performed by scientists and engineers, and it's not that difficult to arrive at a conclusion based on those things that it appear to be fairly obvious after the fact. However, the resultant knowledge is really what we're talking about, and the big question is, if a claim is being adjudicated either by the courts, and quantum tax law has had the experience of arguing against Crown Counsel, who makes similar comments. We've heard in the courts that they've said standard routines have been used, or known methods have been used to resolve the problem. Well, I would assert that if the problem has to be resolved, the problem might be resolved through the use of a standard procedure, but it might be unknown which procedure. In CRA guidance documents, oddly enough, and we realize it's not the law, to paraphrase one of the expressions in eligibility of work documents states that if it is uncertain which path, which route, or which system architecture, and I'm paraphrasing, is best suited to meet the objectives, it's considered an uncertainty. Now, when you consider the term path and route, normally these things are thought to be well-traveled roadways. That's what a path or a route is. I would suggest that, when you consider techniques and known procedures, those could be substituted for their own guidance documents, where it's saying which technique is best suited, which path or route is best suited. And oftentimes these path or routes might be roadways that you've traveled many times yourself. But if it results in knowledge that's not generally accessible, we would suggest that that would be something that needs better consideration to determine whether or not the result was reasonably predictable or not. I wanted to get your feedback on that. Does that concept, do you believe that the entire question of eligibility not only is based upon developing techniques that didn't exist, but perhaps choosing from existing techniques? Could it be that there are 3 or 4 or more techniques that are known, but without experimenting with them and seeing how they affect each other, would you say that that would constitute a legitimate uncertainty?
Oh, I should think so, yes. Why not? You don't know the result that you may use routine engineering procedures, but you don't really know what result you're going to get.